Ladies and gentlemen, I'm really very happy that Ms. Kastelli has come today to deliver a keynote address. Let me say a few words about Ms. Elena Kastelli. Elena Kastelli studied at the National and Kapostodian University of Athens in Greece, where she obtained the degree of law. She then obtained a master's degree of laws in international and European legal studies in Durham University and a doctorate in public international law, also from Durham University. She used to work as an advocate and a pupil advocate of the law firm in Cyprus from 1997 until 1999. A trained advocate, Dr. Kastelli is also of the Cyprus Bar Council. She was the director of the Newcastle Human Rights Group from 2007 until 2008 and a member since 2005. She was offered the opportunity to do an internship at the International Criminal Court in The Hague, Netherlands, in 2005 until 2006, and I think that experience really had an impact also on the way she sees international law and many of the issues that we're also discussing today. Recently, her thesis has been published under the title, "The Problem of Enforcement in International Law, Countermeasures and the Non-Injured State and the Idea of International Community." Ladies and gentlemen, please join me in a very warm welcome for Ms. Elena Kastelli. Thank you.
First of all, I would like to thank you for your patience and for accepting to give away your human right to your lunch at 1 o'clock. But if I can justify myself, I have a 10-week-old baby and I need to run back to her as soon as I can. I don't know whether this is a good justification, but so that you know. It is my pleasure to have been invited to give this presentation at the London International Human Rights Conference, which has this year's theme, Immigration and Integration in an Era of Austerity, Challenges and Opportunities. Indeed, in an ever-increasingly globalized and interdependent world, where restrictions to the movement of persons and to border controls is today a reality, it is very important to consider the rights of another category of persons who are forced to immigrate, if you like, and I'm referring to the category of internally displaced persons. So unlike voluntary immigration for professional or financial reasons, the forcible uprooting of individuals as a result of armed conflict is a human rights issue of significant proportions. And this is owed to the fact that such displacement interferes with fundamental rights and freedoms, including freedom of movement and settlement in one's own country, their right to property, their right to home, and the integration of this category of people in any society. Under certain circumstances, such displacement may also amount to war crimes and crimes against humanity. So this presents us with significant challenges which need to be addressed in the framework of international law, in particular international human rights and humanitarian law and the law on state responsibility. So my presentation today aims to consider some recent legal developments in relation to the rights of internally displaced people as they emerge from a recent decision of the European Court of Human Rights, and this is the case of the mobile laws. So I will briefly give you some information about the facts of that case. This case is related to a complaint brought by a number of Greek Cypriots against Turkey. These individuals complained that Turkey had violated their right to property and their right to home as protected under the European Convention on Human Rights as a result of the Turkish invasion of Cyprus in 1974. Now, the European Court of Human Rights rejected their application as inadmissible on the ground that these individuals failed to exhaust domestic remedies. And in particular, The court held that these individuals, these Greek Cypriots, should have first referred their complaint to the so-called Immovable Property Commission established by the self-declared Turkish Republic of Northern Cyprus. So according to the European Court, this mechanism was effective, was sufficient, and the individuals concerned should have first turned to the Commission before turning to the European Court of Human Rights. Now, the European Court still considers Turkey as responsible for the situation in Cyprus, which remains a problem of occupation. However, its decision raises some significant legal questions in relation to the impact of diplomatic negotiations, political realism, and also the passage of time on fundamental rights and freedoms. It also raises a question as to whether a body established as a result of a wrongful act, namely the use of armed force, can be considered as an effective mechanism of protection of human rights as required by the Convention itself. So I will deal with these legal issues in turn. The first question is the impact of diplomatic negotiations. It is often the case that displaced people are often caught in the middle of prolonged and unsuccessful negotiations between disputing parties, which leaves them and exposes them to further violations of their rights and freedoms. At certain times, the weak party may even be coerced to accept arrangements which further such violations. So I would like to submit that it is particularly important and significant that in any diplomatic or political negotiations, fundamental rights and freedoms must be respected. And quite significantly, not only the rules which emerge from international law, but also the rule of law itself. So any arrangements, any agreements must fully respect fundamental rights and freedoms and must not encourage practices of discrimination and segregation. Now, the European Court in Dimopoulos made extensive reference to the proposed settlement of the Cyprus problem put forward by the former Secretary of the United Nations, Mr. Kofi Annan, in 2004. I would like to submit that such a reference was wrong for two main reasons. First of all, because the plan was not the subject matter of the case before it, and therefore the court did not have the legal basis to examine it. But quite significantly, because the plan had been had been placed before the Turkish Cypriots and the Greek Cypriot communities for a referendum, and it was rejected, and therefore it was not adopted. Importantly, though, the plan was widely perceived, at least from a Greek Cypriot perspective, as violating fundamental rights and freedoms. And I'm not going to refer extensively to the provisions of the settlement. However, in relation to the rights of the internally displaced, the plan did not provide for the return of everyone displaced. It would only allow the return of just 18% of those Greek Cypriots who were displaced in a period of 19 years. A significant weakness of the plan, if you like, was the fact that it did not safeguard the return of the displaced to their traditional lands and properties. So it is of paramount importance that any peace agreement, any peace arrangements must fully respect fundamental rights and freedoms and must not recognize the fruits of the wrongful act. And this is particularly so if displacement is accompanied with discrimination, ethnic cleansing, deportation, forcible transfer, which make it of an even graver form, a war crime possibly, or a crime against humanity. So the court, the guardian of the European Convention on Human Rights, should ensure that the rights and freedoms of those displaced in Cyprus were fully respected, and not give the impression, by making reference to the Annan plan, of punishing the Greek Cypriots for rejecting a plan they did not agree with. The second legal issue I would like to raise is the impact and the role of political realism in relation to the enjoyment of fundamental rights and freedoms. Should we be realistic and just disregard what our rights are, including our right to lunch? It seems that from the court's decision, the court places particular emphasis on political realism on the ground, and it does so seemingly at the expense of the rule of law and fundamental rights and freedoms. And I will read you a short passage from the court's decision to illustrate this point. According to the court finds itself faced with cases burdened with a political, historical, and factual complexity flowing from a problem that should have been resolved by all parties, assuming full responsibility for finding a solution on a political level. This reality, as well as the passage of time and the continuing evolution of the broader political dispute, must inform the court's interpretation and application of the convention, which cannot, if it is to be coherent and meaningful, be either static or blind to concrete factual circumstances. So one may wonder, what is the role of political realism when it comes to the enjoyment of fundamental rights and freedoms? Whilst the political nature of the Cyprus problem is undisputed, it remains first and foremost a legal problem, a problem that must be resolved within the framework of international law. The United Nations Charter itself stipulates the obligation to settle international disputes in accordance and in compliance with principles of justice and international law. So the realpolitik to which the European Court of Human Rights refers to in Dimopoulos is not but just another attempt to allow states to be exempted from the law and the rule of law. And this is, of course, in disagreement with international law, which requires the cessation of the wrongful act. And it dictates that there is, I quote, a need to prevent the completed wrong or the continuing wrong from surviving through its consequences. Accordingly, the political nature of the Cyprus problem does not bring it outside the realm of law. The International Court of Justice itself has stressed that the political nature of a dispute does not preclude it from considering the legal aspects of that dispute. And finally, at the end of the day, it is in circumstances such as this that we need the law, that we need to constrain the state and to ensure that it does not abuse its powers. So the enjoyment of fundamental human rights and freedoms is not conditioned on the non-political nature of a dispute. The third legal issue I would like to refer to is the impact of the passage of time on the enjoyment of rights and freedoms. Do the Palestinians not have any rights because of the prolonged character of the dispute in the Middle East? Or in this instance, do the Greek Cypriots lose their rights to property and to return home as a result of the fact that this dispute has been ongoing for the last 37 years? I would suggest that this is not the case. And this is particularly so when the passage of time is beyond the control of the affected individual. As rightly pointed out, and I quote, allowing the time factor to weigh against the claimant in such a case would result in the legitimization of the state's arbitrary or discriminatory refusal to allow the entry of the individual to his or her own country. So, in other words, allowing the passage of time to work at the expense of fundamental rights and freedoms would work as a mechanism of legitimizing the initial wrongful act of the state. There is also a continuing need to make the wrongful state to cease its wrongful act. And this is in accordance with the law on state responsibility. Article 13 of the 2001 final articles on state responsibility stipulate that a state needs to cease its wrongful act, even if that wrongful act was committed a long time ago. Most importantly, this obligation to cease the wrongful act applies when the wrongful act is of a continuing character. So the point here is that it doesn't matter how long, how much time passes since the commission of the wrongful act, the state remains responsible for this wrongful contact, and it remains responsible, and it has an obligation to terminate the cessation as soon as possible. So dealing with past injustices and protecting effectively human rights and restoring them is an essential component of any peace, reconciliation and peace process. The fourth legal point, which emerges from the court's decision in Dimopoulos, relates to the question of exhaustion of domestic remedies and whether the mechanism established under the Turkish Republic of Northern Cyprus, the Immovable Property Commission, indeed constitutes an effective mechanism of protection. We know very well that under Article 35 of the Convention, individuals first need to resort to their national authorities, to national courts, to complain about possible or alleged violations of their rights and freedoms. And this is justified on the ground that the European Code of Human Rights is not there to substitute national authorities or courts, but rather it works as a subsidiary mechanism and complementary mechanism of protection. However, under the well-established jurisprudence of the European Code of Human Rights, the duty to exhaust domestic remedies does not apply when such remedies are not effective or adequate. And I would submit here that the mechanism before the IPC, the Immovable Property Commission, is neither effective nor adequate. And I will refer to briefly to three legal reasons for that. The first reason is because the IPC is a product of illegality itself. It was established as a result of the use of armed force in Cyprus and the acquisition of territory as a result of that force. And therefore, the IPC cannot act independently from the occupying power. It is also very well established in international law that states must not recognize the fruits of the wrongful act, and this is particularly the case if the wrongful act relates to the violation of a peremptory norm of international law. And I would submit here that the use of armed force by one state against another does infringe a peremptory norm of international law. Now, the European Court of Human Rights justified its conclusion that the IPC was indeed an effective mechanism by making reference to the advisory opinion of the International Court of Justice the Namibia case. In that case, the ICJ accepted that the deeds of a de facto, even if unlawful organ, could still be regarded as lawful under specific circumstances. However, there is a significant difference between the advisory opinion of the ICJ on Namibia from the case before the European Court of Human Rights in Dimopoulos. And that is the Namibia case related to the recognition of deeds such as birth registrations, marriages, and divorce. The Namibia case did not relate to acts which were the product of the wrongful act in the first place. It did not relate to the property restitution or the return of the displaced people. So allowing this body, the IPC, which was created as a result of a violation of international law, to make determinations about the property rights of the displaced people in Cyprus would be tantamount to empowering this body in concretizing, if you like, the wrongfulness and the wrongful situation, the occupation in Cyprus. The Namibia case did not relate to the recognition of deeds which were the consequence or the result of the wrongful act, which is the case in Dimopoulos. In addition to that, we must bear in mind that any remedies must not, and I quote here, must never pose a theoretical obstacle to an international solution. Allowing the IPC to make determinations about the property rights of the displaced would have a significant impact on the rights of those affected. It would alter their fundamental rights and freedoms, and that would be in disagreement with the rules of international human rights, humanitarian law, and the law on state responsibility. The second point, the second reason of why the IPC is not, I would submit, is not an effective mechanism of protection, it relates to the administrative and official character of the violations that continue in Cyprus. According to the jurisprudence of the European Court of Human Rights, and in particular in Activar, an individual does not have an obligation to exhaust domestic remedies if a given violation is part of an administrative and official practice. I would submit that according to Turkey's own declarations, the non-return of the displaced people in Cyprus constitutes such administrative and official practice. According to Turkey's declarations, the non-return of the displaced people would remain unchanged pending agreement on an overall political solution to the Cypriot question. The IPC cannot escape from this policy. It has been established to further this policy and to further the displacement and the uprooting of the displaced. Indeed, in a previous case considered by the European Court of Human Rights in Activar, it was emphasized that the failure of the state to prevent and respond to the abuses points to its inability or unwillingness to remedy the situation despite having notice and the opportunity to do so. The underlying rationale of the exhaustion rule, which is to allow the state to correct the violations, is therefore inoperable under such circumstances. Turkey remains in occupation of Cyprus 37 years after the invasion of 1974. The remedy before the IPC cannot be regarded as an effective since there has been no step by the wrongdoing state to seize the wrongful act and to allow the return of the displaced. A final point I would like to raise relates to the legal validity of the IPC decisions. It must be said that the fact that Turkey occupies 1/3 of Cypriot territory does not alter the sovereign rights of Cyprus, and it cannot alter the fundamental rights and freedoms of those displaced. And therefore, the IPC does not have the legal power or the legal authority to make determinations about the property rights of the displaced as a result of the fact that it is a product of a wrongful act itself. And this is in accordance with international humanitarian law. In particular, Article 55 of the Fourth Geneva Convention prohibits the confiscation of property by the occupying power. Article 49 imposes an obligation on an occupying power to allow the return of the displaced. And this is also in accordance with international human rights law, where the right to property is a right well regarded and well protected, both in customary and treaty law. I would therefore submit that the European Court of Human Rights erred in rejecting the applications in this particular case. It should have found that the procedure before the IPC did not adequately safeguard or address the violations of those displaced, and therefore the court should have taken a different approach in these cases rather than expecting those affected by Turkey's actions to refer to an unlawful regime to find vindication for the violation of their rights and freedoms.
Thank you, Elena. We're now going to have a quick question and answer session. Does anyone have a question?
Thank you. Will Worcester from Hague University, Leiden University. Actually, I have kind of a factual question. You were talking about the case, and I wonder what's happened since then. Have they attempted to go to the local quasi-court procedure, and whether or not it's been resolved through that? Because I agree with quite a lot of what you said, but I'm not sure I completely agree because of this being really a procedural matter of admissibility rather than merits. And in order to be confident that there is no real remedy is to me, we have quite a big burden to show that. And I'm not exactly sure that it's met there simply because there was a violation of the rules against the use of force. So that's because, and I think that there's a good reason for that, because quite frankly, I would prefer for Turkey to correct its problems itself rather than, say, have an international institution or European institution do it. But so the core really of my question is what's happened and whether or not indeed it has been resolved. And if it hasn't, then now we can go back to the European Court. Thanks.
Thank you for your question. Can I answer this question first before moving to the next one?
Sure.
Yeah. Okay. There have been individuals who have turned to the IPC to find justification and to get compensation for the loss of their property. Now, the problem is this. The IPC may, according to the law that has established it, may order property restitution. And according to the facts and figures that I have obtained, and I have obtained these figures not from the Republic of Cyprus, but rather from the website of the IPC itself, the IPC ordered restitution in only 4 cases. Now we are talking about 200,000 internally displaced Greek Cypriots. And even in these cases where the IPC has ordered the restitution in these instances, we haven't seen property restitution in practice. No Greek Cypriot has returned to their home or to their property. So the law which establishes the IPC refers to property restitution, empowers the IPC to offer property restitution, but we haven't seen that in practice. So my suspicion is that, however, I need to mention that lots of Greek Cypriots prefer to opt out for compensation because they are simply fed up. It's been 37 years. They don't see any hope in the horizon, so they prefer to get the money and quit from their property rights. And there are hundreds of Greek Cypriots who have done that. Which raises another question, will Turkey be able to buy the northern part of Cyprus at the end of the day? What are the issues arising from international law in that respect? And this is why I think the European Court of Human Rights should not have accepted the IPC as an effective remedy, because the IPC, with its decisions and determinations, raises other significant issues emerging from the law of armed conflict and international humanitarian law. The European Court of Human Rights did not touch these issues, and it should have done. I don't know whether this answers your question. Was there anything, any other part of the question I didn't address?
Just whether or not, so they have these individuals then lodged claims, had them refused, which we would then expect to be done, and now they've overcome that procedural step in the European Court, and so is there anything that the European Court is displaying?
Yeah, not I am aware of. But your point is valid, because what I would like to see is Greek Cypriots taking their case to the IPC and then referring their case to the European Court of Human Rights, making the claim that at the end of the day the IPC procedure was not effective. However, this relates to the point I mentioned before, that most Greek Cypriots who refer their case to the IPC, they prefer to take the compensation and stop the procedure there. So we have not seen a case of a displaced person today where he or she has gone to the IPC and then they are prepared to take the case even further.
Okay, we've got time for one more quick question.
Hiya, Eric Labelli, staff from Oxford University. Something of a compound question, you'll have to forgive the ignorance on which this is based. First, has there been a determination by a competent juridical authority on the legality of the Turkish intervention in Cyprus? And if there hasn't been, would ruling as you suggest require the European Court of Human Rights to make a determination on the legality, and is that within its jurisdiction?
Yeah, that's a fantastic question, I have to say. No, there hasn't been a juridical determination directly that Turkey has violated the United Nations Charter and customary law as a result of its invasion of Cyprus. However, it has been done so indirectly. We have the 4 interstate judgments of the European Court of Human Rights submitted by Cyprus against Turkey. We have a number of individual judgments, such as the Loizidou judgment, which in effect, what the European Court of Human Rights says is that Turkey has violated the convention as a result of its occupation of Cyprus. So we have not, we did not have an interstate case where Cyprus brought the case before, for instance, the International Court of Justice, because of course Turkey will not accept the jurisdiction of the court. However, we had indirect conclusions that Turkey is in violation of international law as a result.
And would the European Court of Human Rights be competent to make that determination in itself?
In my view, yes, because if you have a claim that your human rights have been violated, a court, any court, will have to consider, why do you make this claim? Where does this claim come from? So in my view, international law should not be seen, or the various fields of international law should not be read or understood in a fragmented way. International law should be seen in its totality. So when we bring a matter before an international or a regional court, this court, in order to make its determination, needs to examine the factual circumstances. Otherwise, it will not be able to deliver a judgment on the crucial point on which it has competence. So in my view, yes, I think that the European Court of Human Rights has and should make such determinations.
Okay, well, on that note, if we could please extend our gratitude to Ms. Elena Kastelli.
Thank you very much. Thank you.